elder law firm. I don't know how many of you are familiar with elder law, so here I go. I'm going to ask you how many of you are familiar with elder law. Just a few. In the legal field, I know many people kind of shy away from attorneys, and I just want to say that in the field of elder law, practicing in this area for over 13 years, the way I like to describe elder law attorneys is that they're really just social workers with law degrees. They are very compassionate people, as we are helping a lot of people in areas of crisis. They come to us for the things that we focus in, and in the area of elder law, we focus in specialized estate planning, asset protection, which I will share with you, is probably the biggest part of our business, where we help people understand Medicare, Medicaid, VA benefits, guardianship, probate and trust administration, disability planning, and elder abuse and exploitation. So those are pretty much the areas that we focus in. At our law firm, as I said, the biggest part of our business is asset protection planning and helping people plan for the future and protect their assets should they need long-term care or assisted care. So many people, I think in general, are under the misperception that if they have just an attorney that maybe help them with their estate planning, that attorney can help them with everything. And that's not so. Attorneys are just like doctors. They specialize in particular areas. So just like you wouldn't go to your podiatrist for a cardiac issue, neither would you go to your real estate agent for elder law issues that you have. So let me talk a little bit about those areas that I just spoke to you about. First and foremost, I'd like to know how many of you have your estate planning documents in order. And when I say estate planning, I mean your power of attorney, your healthcare directive, your last will and testament, maybe a trust. Okay, so a third to half of you, which is great. As we age, we should all have all of these documents in place. And I will say that anyone over the age of 18 should have a power of attorney, a healthcare directive, and a will. Many of us don't think about those things until we get into our 40s and our 50s, or we have children and think, oh, if something happens to me, I should provide for them. I'll share with you, I have twin daughters, and the day they turned 18, I had them come down to the office and sign their power of attorney, their healthcare directive, and their will. And you think, what does an 18-year-old have to pass on? Well, you know, the power of attorney and healthcare directive, they're documents that you need in place to make sure that if you can't make your healthcare decisions or you can't handle your financial affairs, that you've named someone to do that for you. I can't tell you how many times as a mom, my children have wanted me to help them in an area that I get the same response. They're an adult now. They can make their own decisions. And that's true, they can. But what if they couldn't? You want to have those documents in place. So I cannot stress how important it is to have a power of attorney, a healthcare directive, and a will. The power of attorney. A lot of people are afraid to get a power of attorney in place because if you name someone, you're afraid, well, maybe they can take your document and go do whatever they want to do with your finances. I will say to you that a power of attorney is a very powerful document. We don't have springing powers of attorney in Florida, which a springing power of attorney allows someone to take that only with the doctor's statement that this person cannot handle their affairs, and then they take the power of attorney and use it. We don't have those in Florida. The powers of attorney are called durable, which means they survive incapacity, but they are effective upon signing. So you want to make a good choice about who you want to serve as your power of attorney. With that being said, it does not take any rights away from you. It is powerful, gives someone the ability to handle your financial affairs that if you are not able to, but doesn't take any rights away from you. It just gives them the power to do what you can do. There were new laws in 2011 that separated out some of the powers in the power of attorney, most of those having to do with long-term care planning and asset preservation. So if you haven't had your documents done or they are very old, you should have them done. We normally recommend that you have your power of attorney and your healthcare directive executed probably every 3 to 5 years, because you want to take advantage of any changes in the law that allow different powers or more freedom to handle anything that you need to handle or that your attorney in fact needs to handle for you. The durable part of durable power of attorney means that it survives incapacity. And that's really important, especially if you're dealing with a long-term illness, because we become less and less capacitated to handle those things for ourselves. We want to make sure that when we can't, that person can continue to handle those things for us or step in when we cannot. The other thing about a power of attorney healthcare directive will, many people put that off because they think, oh, I put it in writing, it's in stone. It's not, it's revocable. So if you have a situation in which you decide that that person that you named is probably not the best person to handle it for you, or they pass away, you can go create another power of attorney, and that revokes the prior power of attorney unless it's stated in there that it does not. Okay? Any questions about powers of attorney?
I got one. If somebody in the chain that you picked for taking over for you passes away, you recommend to go back and redo that portion of it?
It depends on how it's worded. So there's lots of ways that you can word a power of attorney when you're naming agents. You can name people what we call joint and several, which means that they can act together or individually. So if you had a string of people that you named maybe 3 of them and one of them passes away, the other 2 have the option to be able to take care of anything for you that needs to be done. But if you name them successively, 1, 2, 3, then let's say the second person dies, then when it comes to that, if the first person can no longer act and you're looking to the second one, as long as the third person is there to step in, then that's completely fine. You don't have to redo it. But again, keeping in mind that every 3 to 5 years you should have your attorney review them to make sure that you're up to date with the most current laws and document. Okay. Healthcare directive. Again, it is effective upon signing like a power of attorney. However, the healthcare directive is not used and is not looked to unless you cannot make your own healthcare decisions. So unlike a power of attorney where when you sign it, your agent can go out and act for you, healthcare directive cannot. The doctor has to say that you can't make your own decisions, and then they look to the healthcare surrogate to make those decisions for you. And it does not take any of your rights away again. So if you then, maybe you have an opportunity or you have a situation in which you are not able to make decisions, but then you recover, then that decision making comes back to you, and your agent or your surrogate steps aside. Healthcare directives in the state of Florida contain a living will, and you may have heard of living wills. That is where you state where you do not want to be kept alive by machines or special measures. So they do contain that. Elder law attorneys can specialize that section for you if you don't want certain things, or you do want certain things, or you want certain situations to be considered. That's something you can talk about with your attorney when you're creating that document if you want any of that standard language changed. So that's healthcare directives. Any questions about those? Okay. Your last will and testament. I get something quite often from people that they don't want to prepare that last will and testament because if they do, they're going to die. They might die. And can attest to that. It took her months, months to finally come in and sign a document. It's just such a great security and peace of mind to know that your assets are going to be passed the way that you want them to be passed and that you're protected in the best way possible. When I talked about specialized estate planning, elder law attorneys do focus on long-term issues and the situations that we are going to face, especially if we have a long-term illness. What I would say about that is that with the type of wills that we prepare in our office, there is a special trust that is created for spouses that if a well spouse predeceases a ill spouse, then their assets are protected under a trust within the will that allows that person to get Medicaid benefits should they need them in the future. So if you have a situation where someone's ill, they're being cared for in the home, but if the well spouse passes away, they would have to be placed, for example, in a nursing home, you would want all of those assets to go under that special needs trust to be protected so that when placement occurred, because it probably will, that they could go ahead and get Medicaid benefits and have all of those assets available to them for any special things that they wanted that were not paid for by Medicaid. So So it's really important. As I said, I can't stress it enough, anyone over the age of 18 should have a will, a power of attorney, and a healthcare directive. When you die, what we call intestate, without a will, it can be very messy. Normally what we tell people is as long as you have your assets held together, then that joint person on your asset with you has ability to get to those funds. But when you die with anything that's in your name alone, that can be a real problem, and it can take a long time. Depending on the value, can be expensive. So a lot of people say, well, I don't need a will, I don't have much. Well, you actually have more than you think you do, and it is important to protect what you do have and pass it the way that you do want it to be passed. Sure.
As long as we're on, well, the trust, if you die with a trust, a revocable trust, you shouldn't have to go to probate, do you?
Right. And yes, I'll cover that.
Okay.
Certainly, and we'll go right towards that. A revocable trust, not everyone needs one, but and in our office we don't recommend them a lot, but there are certain situations in which we do. And so if your assets are held in a revocable trust, most people hear, yes, get a trust and you can avoid probate. Probate's not the really bad thing that everyone thinks it is. You can pay anywhere from $1,800 to $3,000 for a revocable trust, but you can also pay that for probate. So, 6 of one, half a dozen of the other when it comes to that. But the revocable trust names a trustee. So if you create a revocable trust and you title all of your assets in the name of the revocable trust, then the trustee would manage those at your death. Okay, so yes, then you wouldn't need so much of the probate issue unless there was something that got left out of the trust and was held in your name alone, and then you have an issue. And sometimes that asset may be just a small bank account, and it's not worth it to go after it for probate because it's more expensive to do the probate than the asset actually is worth. So, there are situations like that as well. The specialized estate planning, which I referred to earlier, is that in our field, we often do have revocable trusts, and then we have the will. Now, I spoke about the trust that's created under the will. In long-term care planning, asset preservation, any trust created under a will is protected for Medicaid purposes, okay? So now you have a revocable trust. What we do is you have a revocable trust, but we call it a pour back. So we pour all the assets back into your will, and they go under your trust in your will so that they're protected for Medicaid purposes should you need those. It's a great planning tool. It's a great protector. So you can have a revocable trust, and it pours back into your will to protect those assets. Or the assets are managed by the trustee in a standard situation where you wouldn't need long-term care.
Now, in our will, our attorneys drew it up so that we were the beneficiary, the trustee, and the trustor of the trust.
Right, and that happens particularly when you are younger and don't have too many issues, or you have the cognition to be able to handle that for yourself. And we create them what we call for each other, essentially for each other, so that even the person that is the ill person, if they pass away, it goes under a trust in a will as well, and it can be protected as well, even for the well spouse. So
You have to have that done.
yes,
Absolutely.
yeah, yes. Listen to this nice gentleman. He says absolutely. So.
Or else you create the Medicaid divorce.
Yeah, you don't, speaking of that, we very rarely recommend divorce because you can avoid it by creating the right estate planning documents. So that's really important. Asset protection planning, that is a huge aspect of our business because, as you heard Mary say earlier, $7,000 to $11,000 a month. Even the wealthiest of people are not really willing to pay $11,000 a month for care. So what we do in our firm is we help, and all elder law attorneys that specialize in asset protection planning, help you look at those assets, how they're structured, and if there's a well spouse at home, how if they're young, you definitely need to make sure that those assets are protected for their lifetime. And we talk about how we can restructure those assets should you need Medicaid or long-term care planning in nursing home. That's the biggest area of focus. If you need assistance, financial assistance, as Ann talked about earlier, the veterans benefit is a really good one. So if you are a veteran and you have not applied for veterans benefits, I encourage you to do so. If you're in the home, and they do have obviously qualifiers for that, and you need to, the easiest way to remember it is if your expenses, unreimbursed medical expenses, exceed your income, then you can get what they call aid and attendance. And you can get that in the home, you can utilize that as you're in assisted living, but when you move on to nursing home care, you can't have both entities paying for your care, so you can't have the VA and you can't have Medicaid paying for that. So once you get approved for Medicaid, then you notify the VA of that. Unless you're going to pay private pay, you can retain the VA if you want to pay private pay in a nursing home, and that can help you reduce the costs of private pay in a nursing home.
Do some of these benefits apply to the spouse?
A widow, yes, and if both people are ill, then yes, you can apply for assistance for both. Yes. But the VA benefit's definitely very helpful in the assisted living setting, or if you are needing care in the home and that care, cost of care exceeds your income. Elder law attorneys versus using some of the Medicaid planning specialists that you see out in the community. I just want to forewarn you a little bit about those. They are there to help you get qualified for Medicaid. They are not there to protect your best interests. And protect you for the long run. Some of them do work with attorneys, but I would be cautious of that as well, because if an attorney is just doing one bit of something that needs to be done for your case, they're not looking at the full scope of your situation. So that's all I really wanted to say about that, is it's really important to pay the little extra that you need to have that reassurance that you're going to be protected and that you have an attorney to fall back on. Guardianship. It has its place, it's very intrusive, it costs a lot of money, and it can be avoided if you utilize the proper documentations of power of attorney, healthcare directive, and a will in most cases, but it does have its place. That's all I really want to say too much about that. Probate or trust administration, we touched a little bit on that. When a person dies, an elder law attorney can help you with the trust administration, and they also can be nominated as a trustee to assist you with trust administration as well. And we talked a little bit about trust, revocable trust. When you create a revocable trust, many people are under the assumption that if they go create a trust, they're done. So they sign a document and they think they're done. I've got a trust. The trust is just a bucket, as we say. So you've got your bucket, now you've got to fill it up. So you have to go transfer your assets into the name of the trust. It's not effective, it's useless if you don't actually fund it with your assets. So if you decide to get a trust and that's right for you, make sure that you do that. Disability planning and special needs trust. If you are disabled and you are receiving public benefits and you want to ensure that you continue to receive public benefits, oftentimes special needs trusts are created for people that, we talked about a car accident earlier. You get in a car accident and you have those assets that need to be protected so that you can remain on public benefits. There's special needs trusts out there, pooled trusts, things of that nature that can help protect those assets as well, so you don't have to use them all up. And the idea behind protection is really to provide some money for you to be able to take care of other things that public benefits won't pay for. So, you know, you want family to come visit you, you need a special lift chair, you want to go on a vacation somewhere. Those are all things that a special needs trust can help you pay for. So that's the real goal, of one of the main goals behind protecting under special needs trusts. Elder abuse and exploitation. Some elder law attorneys choose to specialize in this area, but not a lot of them do, although they are trained to recognize that, as probably, you know, if you go with your gut, you know if there's elder abuse or exploitation happening, and when you bring that to the attention of an attorney, they can talk to you about what options are available to you and how you go about either reporting that or getting someone to assist you when you feel that exploitation has occurred. or neglect or abuse in any way. And they can refer you oftentimes to litigators that will help you do that. As I said earlier, elder law attorneys are really just social workers with law degrees, and they really don't like to fight. So they often refer that out to litigators.